What are past due Social Security disability benefits, and what are the 3 factors that will determine how far back you'll get your benefits? The Social Security disability claims process takes a long time. By the time the Social Security Administration gets around to your claim, they may owe you back pay, or what's known as past due benefits. Let's learn more about those past due benefits or retroactive benefits and the 3 factors that determine how far back in time you'll get your Social Security disability benefits. When you apply for Social Security disability benefits, the Social Security Administration will ask you the date you believe your disability began. Now, that's called the onset date. Under the Social Security rules, there's a 5-month waiting period from the date of disability until you collect your first check. Because the disability claims process takes forever, more often than not, there'll be a past due retroactive Social Security disability benefit that's due. Now, as I said, these are known as either back pay, past benefits, or retroactive benefits. Regardless of what you call it, there are 3 factors that will determine how much you'll get. And I'm going to give you a clue about the first factor. It's the application date. When you apply for benefits, you can receive benefits back to the date of the application and potentially retroactive benefits during the year prior to the application date. Now, this is referred to as retroactive benefits, and these terms can be a little confusing. But if you apply for SSI, your only potential is to get benefits back to the first of the month after which you filed your application. The next factor is the date of disability. Now, the first factor is pretty clear, but the second factor is not always clear. When you file for benefits, you pick a date that you think your disability began. That's known as the alleged onset date. But the Social Security Administration, or ultimately an administrative law judge, may disagree with the alleged onset date and pick another date. That is known as the established onset date, EOD. There are a number of factors that can influence the date, and those can include your medical records, your past application history, and your post-application earnings. Now, on the other hand, for SSI, the date of disability is often a date before the application date, and the Social Security Administration can't set an EOD before the date of the application because your only potential eligibility is to receive benefits back to the first of the month after which you filed your disability application. Now, another factor is the 5-month waiting period. Under the rules, everybody's got a 5-month waiting period, regardless of whether it's SSDI or SSI. And the practical impact of these factors can influence how much you're going to get. But I think the biggest factor is the date your case is finally determined. You might claim a date of disability for January 1st, 2020 and not get to a judge before 24 months. If the judge finds that you're disabled as of January 1st, 2020, you'll be entitled to 24 months of back benefits, but you won't be eligible to receive benefits for the first 5 months. In other words, you're going to get 19 months of back benefits. Now, don't forget that most Social Security attorneys get paid a fee from the retroactive benefits of a maximum of 25% of the back benefits, up to $6,000, whichever is lower. Those retroactive benefits are paid in a lump sum for your benefits, but not for SSI. Any amount of back pay in excess of $3,000 is split into 3 payments made 6 months apart. There are some exceptions to the rule. Now, your eligibility for Medicare as a result of your Social Security disability retirement begins on the 29th month after your established onset date. That's the 5-month waiting period and 24 months of Social Security disability benefits. But SSI is different. If you've been awarded benefits, you're automatically entitled to your Medicaid benefits. I know that's a little confusing, but I think you should ask an experienced attorney such as myself if you have any questions about these issues. I know that making the decision to stop working and apply for your benefits can be tough. And once you've made that decision, I think you should be reaching out to an experienced Social Security disability attorney who can guide you through the Social Security disability claims process. Submit your medical records, a winning RFC form, and deal with all of the forms that go with an initial application and a request for reconsideration. Now, if your claim has been denied, don't go it alone. You need assistance in gathering and submitting your medical records, filing winning forms, and preparing you for your big day before the administrative law judge. We make sure that our clients understand what happens at a Social Security disability hearing. We meet with them and go over all the questions that they are asked and how to answer their questions in a truthful manner that tells their story in a way that the Social Security Administration will understand. And we even have videos about that. that make sure that you're absolutely prepared. That in-person meeting will take place at least 5 weeks prior to your hearing, and I meet you the morning or the afternoon of that hearing and get you prepared again. So you're going to walk into that hearing knowing all the questions that you're going to be asked, how to tell your story truthfully, and you'll feel confident in your ability to explain why you're entitled to your Social Security disability benefits in a way that addresses the 5-step sequential evaluation. So don't delay. Call today, 727-894-3188 for a complimentary consultation.